Hello everyone, this is Daman. Today I'm going to cover the topic employer-sponsored visas and 407 training visa, current issues, emerging trends, and future directions. I'm working as a senior immigration lawyer with Kris Ahn Lawyers. I got admitted as a solicitor in 2023, and since then, in September 2023, I started working with Kris Ahn Lawyers. I specialize in student visas, employer-sponsored visas, and range of migration matters. Today's objectives of the session are skills in demand visa, where I'll be talking about key listings, processing insights, employer nomination scheme, which is ENS 186 advances, strengthening employer compliance act 2024, 407 training visa purpose, issues and integrity concerns, emerging trends shaping 2025-2026, and future directions and practical recommendations. So let's start with the skills in demand, which is now called as SID 482 visa. It used to be TSS 482, which was replaced by SID on 7th of December 2024. There are three streams, which is like specialist, core skill, and labor agreement. Indicative salary floors are like specialists are high earners, core skills are TSMIT or AMSR, so which is minimum $76,515, and this changes every year in July. So most probably from 1st of July, there will be new TSMIT. And there are pathways to PR via ENS, which remains central for 482. What it means, like sponsors must align roles to their to CSOL or labor agreement. The remuneration must meet AMSR and threshold settings, that is $76,515 per year. Role designation and scope should be matter more than ever, so they should be aligned with ENSCO, so it shouldn't be irrelevant job duties in the position descriptions. And processing performance varies by stream, so all these three streams, they have different processing times. You can apply for the nomination and visa for up to 4 years, and work experience requirement is 1 year in the last 5 years. Applicants must nominate an occupation on core skills or special skills occupation list, which is available online. There is a core skills occupation list, which is called as CSOL as well, so that's totally different, and it includes variety of occupations. And employers must meet the new temporary skill migration income threshold, which we call it TSMIT, that is 76,515, and LMT is required unless it's exempted. So like if someone is from Korea, Thailand, they are not required to do LMT. Someone from India, they have to do that. So there are exemptions which we go through whenever we receive the clients. So let's discuss about the processing times and operational measures. So specialist stream normally takes median 14 days, but it can be more. It's a general standing processing time by the department. Core skill stream, it's median 82 days, but it's taking normally as of now 5 months approximately. And labor agreement stream is 4 months. And TSS visa comparison is like 10 to 30 months average. So all the applications which are lodged as TSS, so they are taking longer time to process. And the most important thing is if the applications are lodged as a decision ready, like medicals, police checks, all other relevant documents, experience, everything is provided, the processing can be much quicker. So let's talk about the occupational and salary trends. So specialist skills top roles, mostly the people who fall in this category are medical practitioners, analysts, programmers, engineers. Their income threshold is 141,210 for the financial year 2025 to 2026 until June 30th. So most probably from 1st of June it will increase. Core skills top roles are like food trade workers, automotive, electricians, mechanics, ICT analysts. So these are the main occupations which are mostly applying for 482 visas under CSOL list. And then labor agreement roles increasingly, which are aged care, meat processing, and regional sectors. So these are the three different streams where different kind of people apply for the 482 visa. Let's talk about the ENS employer nomination scheme. There's a practice shift in that. So there's an expanded PR pathway. Like once the person works for 2 years on 482 visa, they are eligible to apply for 186 TRT stream, where they need to meet specific criteria. And second stream is direct entry, where a person have a 3-year work experience, they can directly apply for 186. But most of the people, they apply for 482 depending upon their work experience length. So if they have only 1 or 2 year experience, they go for 482 and then jump onto 186 TRT pathway. So the key factor is short-term streams gaining durable PR routes. Top occupations, again, analysts, food, trades, engineering professionals. And the processing times for direct entry is 12 months to 18 months normally. TRT is again 18 months and LA is approximately 5 months. But as department says, 12 months to 18 months, it can sometimes be quickly processed within 6 months as well. So these time frames, they change, and depending upon how your file is presented and is it decision ready, then it definitely makes a change. There was a strengthening, they improved it. So Strengthening Employee Compliance Act 2024. So this act is to combat exploitation of temporary migrant workers, including those on student, working holiday, or temporary skilled visas. So this new compliance regime targeting them and exploitation and underpayment. And what happened in September 2025, in Perth Hills, is that this Italian restaurant was prohibited for until 2030, September 2030. They cannot sponsor any new migrant workers because they have breached their sponsorship obligations and they have found not following the proper conditions. And here's a link for the news from the department, so you can have a look at it and go through it. But this is pretty good because then they will be covering all the sponsors or the employers who are not paying their employees correctly, they are not keeping the records, or if there is MSR is 76,505 and they're paying less money. So all these things will be covered in this Compliance Act. And there is enhanced data matching between ATO and Home Affairs to detect breaches. So what happens is, example, working on student visa, they are working more than that period, so driving Uber or doing something else. And if employer is paying them salary, and if it matches with the data, ATO data, that's fine. If it doesn't match, then it's obviously a breach, and it goes to the employer as well. And there's increased penalties, like penalties for breaches for work-related conditions, employer sponsorship obligations are increased, and most of these are covered under a criminal offense or civil offense for employer or labor hire company. So let's talk about subclass 407 training visa, surge and integrity challenges. There is an increase in 407 training visa applications as compared to 2017 to 2024 because the department changed the regulation where no one holding a 485 visa can reapply for the student visa after expiry of 485, and they can apply, but they have to go to offshore. So that's why a lot of people started applying for the 7 training visa, and which they feel is that it's like just people are just trying to buy the time, and they're not a genuine temporary entrant for 407 training visa. The processing time for 407 training visa application is 8 months. You need to provide the training plan, training agreement, and there is a compliance where department is watching on the training plans if you are keeping the record or not, the employers are keeping record or not. And as I said, that onshore applications affected by student visa applications and subclass 408 closure. So a lot of people who don't have any other option, they apply for 407 training visa. And enhanced data matching between ATO and Home Affairs to detect breaches, and it increases civil penalties and sponsor monitoring powers. Integrity and compliance concerns for 407. There's evidence of 407 misuse for string extensions rather than genuine training. Principle is genuine training, not filling skill shortage. So what they mean to say is 482 is used to fill skill shortage. So where 407 is only for the training purposes. So people who are misusing it for the extensions, they will be in trouble, or they can be checked by the department, are they complying with the training plan or not. And there are increased refusals for programs lacking structured learning or supervision. So GT is the main reason for the visa refusals, where they feel that the person is not generally intended to do the training, so they're just extending their stay in Australia. So that's the main reason why 407 training visas are being refused. And DHA, as I said before, DHA is auditing training plans and training outcomes, so which is more important now, and scrutiny on mentor credentials and competency alignment. So whosoever is your mentor, whosoever is your trainer, they will be checking the credentials, and they will also check the, as discussed, training outcomes on your 407 training visa. Policy and systematic developments. There's an ongoing refresh of CSOL to reflect workforce demand. So most probably, as we received the CSOL, I think last December, hopefully we'll get something this year in December or next year in June. And then further indexation of TSMIT thresholds, which will be in starting from 1st of July onwards, they will increase it. Automation of low risk processing for skilled in demand specialist streams. So that will be, I think, good thing to do, because a lot of people who keep waiting for the visas, and if everything is good and their application is positive, it will be processed automatically. So that will be better option for people who want to apply under specialist stream. And potential liberalization of essential skills pathway for regional employers, that will be again a new added advantage. And ART reviews, as we heard before as well, that there will be more paper-based reviews, basically more for the student visa applications, as ART has received a lot of visa applications, student visa application refusals, and a lot of applicants applied for the review, and that they can be decided on paper-based. So it might happen in coming future that this keeps going on for most of the applications. So whenever you are lodging your ART review, you should be providing all the information and all the relevant information with your application. So there will be implications for employers and practitioners. So expect stricter documentary checks under employee compliance reforms, and then align job and salary bands with CSOL and NSCO mappings. Encourage early PR planning within 186 pathway, 2 years eligibility. So most of the people who are working on 482 example, so if they want to apply after completing the 2 years, so then they need to make sure there are no unpaid leaves or anything which is not consistent with their work experience while working on 482. So they need to make sure everything is in appropriate manner so that they can meet eligibility. And 407 sponsors to maintain logs, rotation plans, and outcomes evidence. So there will be more paperwork for them to maintain all these records. And again, ART reviews, more paper-based reviews will be done. Practical recommendations for sponsors. So maintain audit-ready position descriptions mapped to CSOL. Document AMSE calculations and salary benchmarking for each nomination. So which is they need to keep all the records. And conduct internal sponsor compliance audits annually. So what they can do is they can do it themselves, or they can hire someone from outsource and match all their data, do the internal audit, so that they can see that if there is anything missing, they can fix it up. And then pre-law checks, skill assessments, licenses, and references verified. So if you're going to apply for anything, being a lawyer, I always check all the skills assessments are intact, valid, not expired. All the licenses are valid, and any references they provided, they are genuine, and they are providing all the information on the references, like employer name, their contact details. It's in a business letterhead, so all these things matter. So it's our job to check it out. And reminders for visa expiry, any PR transition. So if person is about to finish 2 years, so you should be putting reminders for that. And then the training milestones for 407 training visa. How Kris Ahn Lawyers can help? We provide the tailored advice and plan for employer-sponsored visas and 407 training visas. Strategic case preparation to mitigate refusal risk. Expert in handling reviews and appeals. If you need any help, any consultations, so book a consultation with us today, so we can prepare and we can guide you through for your PR, work visa, employer-sponsored visa, or any kind of visa support. What we covered so far was skilled in-demand visa, key listings and processing insights, ENS 186 advances, how Strengthening Employer Compliance Act 2024 came into effect, and how they are prohibiting employers for 5 years at least not to sponsor any migration workers, and then 407 training visas, what is the purpose, the issues, which is like people are using it as extending their stay in Australia, so integrity concerns in there, and emerging trends shaping 2025, and where there are options like ART is going to be on paper-based decisions for student visas, and other applications as well can happen. And yep, this is what I wanted to cover in this. If you need any information, please contact us on any of our email ID over here, info@krisahn.com.au, or you can give us a call at 0272550101, and please follow us on all the social media, and we are always there to help our clients. If you need any information, please book a consultation with any of our lawyers, and we will be there to help you out. Thank you.